Good evening, ladies and gentlemen, and welcome to a very special episode of Nice with Nicci. Um, you guys, I'm just coming off of a really great conversation. Shout out to Ice Cream Conversations. I did an interview with her, and I'm just always grateful when a blog or a Black owned media company decides to give me the platform and the opportunity to magnify my case, to magnify my advocacy. So shout out to Jasmine Brand and Shade Room and Baller Alert and Ice Cream Conversations and Hollywood Unlocked and all of the places that are owned and operated by Black or BIPOC people. And just always grateful for the opportunity to share. So that conversation inspired me. I've been wanting to do this for quite some time, but I was like, nobody's that interested. Nobody really cares. But and Tori Hart, if you have not had an and B Hot. See, you start naming people, and then you got to remember everybody. So if you have given me be High, Brutally Honest with Tori Hart, AIB. If you've given me the platform, TV1, thank you. If you've given me a platform to share my story or my art and my creativity, or if you've taken the time to come to WIRF Media, which is our platform, and engaged, thank you. Thank you, thank you, thank you from the bottom of my heart. Thank you. It means more than you know. So I had been going over this with my team and just wondering whether or not I should do this, whether or not people would even be interested. But I felt like it was important for me to finally do what I'm about to do today, which is I'm going to go through, and this may be multiple parts because I know folks got things to do and attention spans are growing shorter every day. But I'm going to read the writ of certiorari that I filed with the United States Supreme Court. Now, a lot of people have probably wondered why I think that my case is worthy of the Supreme Court with all the things they have going on, is worthy of their consideration, right? And I know that there are plenty of people who are huge fans of P Valley, which is the show that I'm in litigation with currently, who probably don't understand, and some people don't want to understand, and some people just don't understand because, as I've learned in my journey for 5 years, it's been this legal thing is deep and intricate, and people go to law school for a reason. It's a lot. And I know that if you don't have all the facts and the information, it could be a little confusing. And sometimes people just don't even really care. Sometimes people just want their favorite show back on air, and it was an escape for them. And I understand that too. But for those who do care, for those who understand that this fight and taking it to the highest court is not just about my ego. It's not just about me wanting attention or clout or to destroy someone else's opportunity. This is about me standing up for constitutional rights to due process, standing up for plaintiffs or defendants in cases to have the right to present evidence to a jury so that they can have a fair trial or a fair outcome. And what people don't really understand is that in criminal cases, you are guaranteed the right to due process. You're guaranteed the right to a jury no matter what. But in civil cases, you can be dismissed summarily on something called summary judgment, which basically is when the judge decides for him or herself that there is nothing to see here. These things are apples and oranges. This is frivolous. This means nothing. And they dismiss it without it going to a jury. Obviously, there are some cases that are so frivolous that deserve to just kind of, be thrown out, I guess, right? But then there are others where there is a question. There are others that require expert testimony. There are others that deserve a jury. And it is my belief that my case is in fact one of those cases. The other thing that this Supreme Court petition will hopefully do for all creatives is it will help us establish without a doubt whether or not underfunded creatives stand a chance at fighting multi-billion-dollar corporations. Because what most people don't understand is that the law is established based on precedent, based on previous cases and how those cases turned out. And if every time there is a copyright infringement case, or every time there is a creative or any individual going up against a major corporation, they are constantly met with an endless supply of resources where the defendants in these cases can outspend them. You know, you will never get to a point where there's actually a level playing field and equal opportunity for justice for all in this country. I believe that if I had more opportunities financially, I would have more opportunities in this judicial system. So while initially my case was centered around P-Valley, initially my case was centered around whether or not Lionsgate stars Katori Hall infringed on my intellectual property right. Now that I have been denied at every turn in the judicial system, now that I believe I've been denied the right to due process, the constitutional right to protect my IP, it has become a bigger conversation. It has become more of a conversation about what you can present as a plaintiff, where in most cases it's supposed to be seen in the light most favorable of the plaintiff or the non-movement. What you can present and what does it mean for a judge to abuse their judicial discretion in making a determination as if they were a trier of fact? What makes something so frivolous that it does not deserve an opportunity to be heard by a jury of my peers? And why, as an underfunded plaintiff struggling to pay my own legal fees, was I straddled and punished, quite frankly, by being required to pay the legal fees of the defendants simply because I asked the judge for a trial? I am millions of dollars in debt because of this case that I never had a chance, never had one opportunity to go before a jury or to have a real hearing before a judge. Never once. If the Supreme Court decides that this case is not worthy of going forward based on the questions that I am requesting they answer, then the good thing is that we'll save other creatives the hell that my family has gone through, the bankruptcy that we will inevitably have to pursue. What was created to help provide generational wealth and generational wellness to my family has now become something that for generations we're going to have to work to recover from. All because I asked for a fair trial. What system punishes an underfunded creative for asking the question, especially when the facts remain? I gave my materials to the CEO of Lionsgate, met with him and pitched the story, copyrighted those materials over 10 years before they did. And there was evidence from my expert that there's no way P-Valley could have been created without being influenced, inspired, infringing on the rights of Soul Kittens Cabaret, and that too was thrown out. How do you fight hogtied against a major corporation? What does this say for the future of copyright protection? So, I'm going to stop bumping my gums and get into this petition. I'm very, very proud of this petition. I filed this petition as a pro se litigant. That means, pro se petitioner. Let me get my words right. I filed this as a pro se petitioner. This is an actual copy of the writ that is filed with the United States Supreme Court. I'm going to go over that with you all. It is currently in the United States Supreme Court. Yes, I have an honorary doctorate, so I am Dr. Nicole Gilbert Daniels versus Lionsgate Entertainment, which is the parent company, or was, I believe, I don't know, maybe some changes with P-Valley. And this is in petition for a writ of certiorari to the United States Court of Appeals for the Ninth Circuit. So a lot of people have been asking in a lot of interviews, let me scoot over a little bit. Okay. So in a lot of interviews, people have been asking what it means, what the writ of certiorari means, and what the point of it is. So certiorari means to know for certain, to find out for certain. And that is what I am looking to the Supreme Court of the United States to do. Now, another point I want to make before I start reading this, and I'm only going to read the petition portion of it. I think another day I might read, the actual summary judgment motion that Judge Wilson, the federal judge in Los Angeles who denied my case, and is issued a judgment for me to pay the defendants' legal fees. I may read that summary judgment motion as well, just because it'll always be here. It'll always be available to people for reference. Now, I want to say this real quick also before I start reading this. We are currently headed into the Justices' long conference, which is September 29th. I'll go back to that. So this is a very important point I would like to make. We have, since filing this writ, which we filed in May, or June. Was it June? May, I believe. We have been accepted. We have gotten as far as the Justices Conference, which is a really big deal. Now, for some people, be like, it means nothing. But as a pro se litigant, meaning I did this by myself, that is huge. I mean, I think it's huge for any petition to be in a closed door conference with just the 9 justices, right? So this is huge, huge, huge for me to know that a young woman from Detroit, Mansfield, Cody High School, theater geek, recording artist, creative, actually has a petition that could change how creatives are protected in the United States Supreme Court is just a huge win in my spirit and in my soul. And I know that our ancestors are proud and pleased. And if that is as far as it goes, the fact that they have read and heard the perspective of someone who really cares deeply for creatives and for artists, and who I've spent my life and my career helping build platforms and opportunities for others. And my family, it means the world to me that the judges felt like it was, justices and the clerks felt like it was worthy of them discussing during their long conference in September 29th. So remember that date, and then I'm going to get into this here. Writ of certiorari, which is just a request. And the other thing is, this is just me asking the justices to grant me the opportunity to be heard before the full court. So they discuss in this meeting the cases that they will grant certiorari on. So then the next phase is that I argue the case. Now, Lionsgate and Stars, since this has been filed, Lionsgate and Katori Hall, because she has separate representation. And this can all be found, it's all public document. It can all be found on the United States Supreme Court website. But they waived their right to respond, meaning they didn't, for whatever reason, want to dignify my petition with a response, probably because they felt like, because I'm a pro se litigant, they're going to throw it out. But they didn't throw it out. They scheduled it for the long conference. And then the week after that conference, which is October 7th, which, Lord God, Jesus, please pray for us, because that is my husband's birthday. We found out that the appeals court denied us the day of his father's funeral, right before the holidays, December 16th. And then we're finding out whether the Supreme Court is going to let us go forward on his birthday. And we just, not to play the small violin, but we have been through hell. And either way, October 7th is a big day, as is September 29th. And this is what the judges the justices, my apologies, justices, only the justices, no clerks, no staff, just them in a closed door conference. My petition is one of hundreds that they will be reading. So I'm going to share that with you guys now, and hopefully you can appreciate it because I put a lot of work into it. I'm proud of it. And I'm praying to Jesus that the justices believe that it is worthy. So the first thing you have to do, and I learned a lot because I actually submitted this writ twice and had to have corrections done. And they actually asked me to do a supplemental appendix, and I'll explain what that means. It was my side-by-side comparison chart. As a pro se litigant, I'm sorry, not pro se litigant, pro se petitioner. As a pro se petitioner, you have to file your writ of certiorari in a book form, paper, right? Written. I'm sorry, I said book form, paper, written. In a booklet, right? Very specific font, very specific size, very specific. I did not follow those specific instructions. However, by the grace of God, I was given the opportunity to fix it, to adjust it. So I had to file 40 copies of this booklet and 40 copies of the supplemental appendix, which was the side-by-side comparison. The reason I had to file the 40 copies of the side-by-side comparison is because it wasn't a digital. If I was a lawyer, I could do it electronically, which would have saved me a ton of money, right? But I'm not a lawyer, I'm pro se, so I had to do it on paper. So I had to print these booklets, which was not cheap, as well as the side-by-side comparisons, because they can't just click the link and watch the Vimeo video and all that other stuff. So this is the actual filing, and I'm gonna quit rambling and just get into it. Thank you guys for joining me on this special episode of Nights with Nicci, baby. Matter of fact, hold on, before I get into this, let me make sure I get my branding in pocket. You feel me? There we go. Okay, so you have to first start your writ off by presenting questions. So these are the questions you present to the justices that will hopefully result in you getting your writ granted. So my two questions are, you can have one question, two questions, three questions. I don't know that there's any limit to the number of questions that you can ask the justices. But my questions presented are substantial similarity and summary judgment. Does the Ninth Circuit's application of the extrinsic test and its requirement of striking similarity conflict with other circuits or Supreme Court precedent? And did the lower courts err in granting summary judgment by finding no substantial similarity as a matter of law? Basically, what that is saying is that there is something called an extrinsic test, which means that you take out all the things that are considered scenes of frere. Extrinsic tests, scenes of frere, all of these things were developed or created, or the precedent was set based on previous cases, right? So like Judge Paez, who's a Ninth Circuit judge, made a comment saying, what exactly is scenes of frere? Where scenes of frere is something that was created as a result of a copyright infringement lawsuit that was created as a measure of things that would occur in a normal situation. If it's about a restaurant or a bar, you're going to have waitresses, you're going to have patrons, you're going to have alcohol, you're going to have basic things that sort of are free domain. It's free for every creative to use. So that once they take out the scenes of frere, the common things, that is an extrinsic test where they extract those common things, what you're left with, was that enough to be considered substantially similar? And when you start talking about story and characters and mood and pace and stuff like that, which we'll get into, those are the things that are protectable. So again, the question is whether or not the court erred in granting summary judgment, which means throwing my case out before it went to a jury, by the substantial similarity doctrine, which was created based on other cases. Okay? Expert evidence in copyright infringement is the second question. Whether the Ninth Circuit erred in affirming the exclusion of petitioner's expert report and declaration offered to highlight substantial similarities between the works at issue, thus depriving petitioner of critical specialized analysis and raising due process concerns in the adjudication of complex copyright claims. So, to break that down, because I am a creative and the Supreme Court set precedent that expert testimony does and can assist you in evaluating whether or not there are some similarities. So it's not just me saying there are similarities or Lionsgate saying there aren't similarities. It is someone who is a trained expert with years of experience comparing the two works and saying, hey, there's a high likelihood, a medium likelihood, maybe perhaps, or not at all. And in my case, because we weren't given discovery, we were given 60 days of discovery, which is unheard of. Some discovery goes on for a year. We weren't supposed to have discovery. Initially, the judge denied us discovery, but then I guess figured that it would be overturned by the Ninth Circuit, so he should give me a little bit of time to do it. So they gave us a little time, and we used that time to hire an expert so that that expert could come in and say, hey, this is this or this is that. Now, here's a key in that. They threw out my expert's report because they said my expert was just parroting me, saying what I said, had the same things to say about it that I did. And instead of strengthening my case at both the federal court level, which is the first court that I went to, and I was there for a couple of years, and then the appeals court after the federal court threw it out, all said, well, the appeals court agreed with the federal court, and partially because you have to give a high degree of deference to the federal judges. That's another law and a precedent you have to really consider. So if you go back and you look at my, I had a video where we broke down the appeals hearing that I had on December 6th in Los Angeles, in Pasadena. He said, even if you didn't agree, you still have to give a high degree of deference to what Judge Wilson said. So that is kind of, unfortunate because again, it is not a level playing field. It then becomes judge's word is law. And that as a matter of law is really important to remember, because you'll notice that you hear as a matter of law come up a lot in this petition. It came up a lot in my claims. And that is because that is what court is about. It's about looking at past precedent and past laws and determining whether or not those laws and that precedent can apply to this situation. For example, there's something called a Dubert analysis, D-A-U-B-E-R-T. The Dubert analysis is something that was created so that experts could determine whether or not something was the same or had a similar formula. Now, here's something important for you guys to recognize about the Dubert analysis, which every case uses that because it is established by the high court. This is what we use to measure whether or not there are an expert, is using the scientific way of breaking down whether there are similarities. So here is what I see as a flaw in that. The Dubert analysis is based on a pharmaceuticals company, a case about science and elements and pharmaceuticals and ingredients. And how is that analysis being used to determine a creative, subjective, derivative work in creative story? How is it that although my expert did follow that Dubert methodology, extracting the things and putting them together and blah, 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 but that is based on a scientific pharmaceuticals company structure. How is it fair to judge a case about how a play was adapted into a dramatic series? How's it fair to judge an expert's opinion based on that and to decide as a matter of law that this expert's opinion holds no value, but a judge who, in the words of Ninth Circuit Judge Wardlaw, which we'll get into that. I'm going on a tangent. I'm supposed to be taking y'all through this here writ. So I am going to focus on doing that. Okay, wait, where are we on page? Related proceedings. We don't need to do any of that. Let's just get into the meat and the potatoes of it. These are appendix pages and tables of authority and all of those fabulous things. What page are we on? We are on page, we've already skipped down to page 9. Okay, so basically this is the reason for this petition for writ of certiorari. This case raises urgent constitutional and doctrinal concerns about using expert testimony, the proper limits of judicial discretion at summary judgment, and the fundamental right to a jury trial in complex copyright disputes. The Ninth Circuit affirmed the district court's exclusion of petitioner's expert report and granted summary judgment to the respondent, effectively terminating the case without allowing a jury to evaluate critical evidence of substantial similarity between the parties' works, and in doing so, the lower courts disregarded the standards articulated in Dubert and this court's ruling in Anderson versus Liberty Lobby, which cautioned, the non-movant's evidence is to be believed, and all justifiable inferences are to be drawn in his favor. Credibility determinations, weighing the evidence, and drawing legitimate inferences from the facts are jury functions, not those of a judge. Despite offering a professional, independently conducted analysis based on establishing industry methodologies, the petitioner's expert was dismissed as merely parroting the plaintiff. This exclusion ignored the reality that experts often corroborate a plaintiff's claims precisely because they analyze the same creative material through a trained lens. As the Ninth Circuit itself recognized in Zindel versus Fox Searchlight Pictures, right? And that is another case. So there's always a reference to, you'll see a lot of references to cases. Additional evidence, including expert testimony, would aid in the objective literary analysis needed to determine the extent and qualitative importance of the similarities, particularly the plausibly alleged shared plot sequence. Indeed, as Judge Kim McLean Wardlaw remarked during oral argument in Zindel. So this is an appeals court judge in the Ninth Circuit, which is the same circuit I was in, and what she had to say about judges making these determinations. She said, and I quote, "I think it's kind of a hubris for a district court judge to think they have enough knowledge and basis in film and theory, things that people go to school for at USC, UCLA, to learn all about, that they can decide on this in just the motion to dismiss stage, except in rare cases where it's just obviously so frivolous. The exclusion of my expert testimony gutted the petitioner's case and denied her an opportunity to have disputed facts evaluated by a jury. Compounding this error, the panel applied the Ninth Circuit's rigid extrinsic test, filtering out protectable elements and requiring a striking similarity in arrangement of those that remained, a standard that diverges sharply from the more flexible, jury-centric approaches followed by other circuits. This fractured and inconsistent landscape of copyright adjudication requires this court's intervention. Certiorari is necessary to resolve the conflict, reaffirm the jury's constitutional role in weighing expert testimony and factual disputes, and restore due process protections to under-resourced creators seeking justice under the Copyright Act of 1976. So then the next sections are the opinions below, which are basically, and I'll read this because, yeah, this is important for you guys to understand that as well. So it's just basically the process, the steps that I went through. The Court of Appeals for the Ninth Circuit on December 16th. These are the things that are, forgive me, these are just copies of the orders that you have to file with the court. Where are we on page 12? All right, hold on. Let me get to page 12. Okay, those are just, this is important. Statutory and constitutional provisions, right? So whenever you go to the Supreme Court, you know, one of the big things that is at issue with the court is whether or not your constitutional rights were violated. So there's a section, statutory and constitutional provisions, U.S. Constitutional Amendment due process. No person shall be deprived of life, liberty, property without the due process of law. The U.S. Constitution, Article 1, Section 8. Congress shall have the power to promote the progress of science and useful arts by securing for limited times authors and inventors the exclusive right to their respective writings and discoveries. This clause is often called the intellectual property clause, right? And then, of course, copyright protection. Copyright protection subsists by this title in original works of authorship fixed to any tangible medium for expression, including literary foreworks, musical works, dramatic works, motion pictures, and other audiovisual works. Ideas are not protected. In no case does copyright protection for an original work or authorship extend to any idea, procedure, process, system. So these are just sort of the standard reminders, if you will, of the constitutional issues that could be at play here. And then, this is really important. Federal Rule of Evidence 702, testimony by expert witnesses, right? A witness who is qualified as an expert may testify in the form of an opinion or otherwise. The expert's scientific and technical or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. The expert has reliably applied the principles and methods to the facts of the case. So again, you see the word scientific and technical comes in, which at this point, that is what we have to rely on in the court, because it was a Dubert Pharmaceuticals case that established the precedent about expert testimony. However, this is a real opportunity for my case, which is a case about copyright, which most copyright infringement cases, okay, let me slow down because I get real excited, you guys. This is a lot. But the reason I get so excited is because my case is a great vehicle, which you'll get to the vehicle statement at the end of this, for the Supreme Court to establish importance of expert testimony in creative works. There hasn't been anything having to do with a rule for expert testimony established in copyright law, especially as a result, especially as it relates to summary judgment, because that is the tool that all federal courts have used historically to get rid of these copyright infringement cases. It is the easiest card to pull, right? And it's unfair. Okay, so this is the point where we go into the statement of the case. Thank y'all for riding with me. Thank y'all for riding with me through this. I want y'all to see I did a real good job putting this writ together, but it is very important information in here. And the judges are reading this thing that we're reading, and they're going to discuss it at their conference on September 29th. So I figure, why not share it with our WIRF.TV audience? Okay, so this is the statement of the case. So this is where you basically give the judges or the justices the factual background, okay? So petitioner, Dr. Nicci Gilbert Daniels, and that HC is honorary, right? Is a playwright, producer, and recording artist. She created an original musical stage play and related works titled Soul Kittens Cabaret. Soul Kittens Cabaret consists of 2 stage play scripts written in 2006 and 2010, and a filmed staged performance released online and on DVD in 2011. These works center around an African-American cabaret club called Soul Kittens Cabaret in Detroit, Michigan, featuring a troupe of female performers and the interpersonal and business challenges that they face. SKC's storylines incorporate themes of sisterhood, struggle, personal redemption, and faith, presented in a stage play format with periodic song and dance numbers. For example, in SKC, the club owner, Tata Burlesque, is a gay, gender-fluid man who inherited the club from his late partner, who struggles to keep the venue afloat in the face of a takeover attempt by his partner's son. This homophobic antagonist harbors ill will towards Tata and plots to seize the club for a casino development. Throughout SKC, the characters must adhere to specific commandments, rules of the club, to retain their stake in the business, and the antagonist attempts to trick them into violations that would forfeit ownership. The tone of the petitioner's work blends entertainment with moral lessons, often evaluating its characters through a lens of challenges and redemption. So that is the explanation of SKC. Here's the explanation of P-Valley. Respondents, and petitioner is me, respondent is the defendants, Lionsgate, Katori Hall, P-Valley, Patrick Ann Polk, Liz Garcia, Shernan, and those folks. Respondents are companies and individuals involved in creating the television series P-Valley, a dramatic series that premiered on the Starz Network in 2020. P-Valley is set in the fictional town of Mississippi at a strip club called The Pink. The club in P-Valley is owned by a character, Uncle Clifford, a gender-fluid person who inherited the establishment from a family member. In the show, it's Clifford's grandmother. The series follows the dancers and staff of The Pink as they navigate personal struggles, crime, and community pressures. The central conflict in the first season of P-Valley involves efforts from an outside party, a local homophobic mayor, and developers to purchase or foreclose on the property for a casino development. At the same time, Uncle Clifford fights to save the club. P-Valley has a gritty, contemporary tone, emphasizes the harsh realities of its characters, their lives, poverty, abuse, corruption, and survival. Spiritual and religious themes come up in P-Valley with the character Patrice Woodbine, the overly religious mother of one of the lead dancers. The series is presented in episodes and ensemble drama format. Petitioner's 2-hour musical stage production is performed in a live theater and did not have the large development budget of P-Valley, but the central story has the same beginning, the same middle, and the same end. Petitioner, that would be me, alleges that P-Valley is substantially based on Petitioner alleges that P-Valley is substantially based on or derived from Soul Kittens Cabaret. She contends that the creators of P-Valley had access to her work. Petitioner left copies of her stage play and her derivative work, which was a dramatic spinoff, with Lionsgate executives when she pitched it to them as a drama series in 2013. Petitioner's stage play has become publicly performed and distributed in SKC since 2007, and numerous specific elements of P-Valley, its characters, settings, plot lines, and themes are strikingly similar to those in SKC. For example, both works feature a nightclub primarily featuring Black female exotic dancers. This LBGTQ club owner inherited the venue from a loved one. A homophobic antagonist figure, attempting to take over the club for a casino project, supporting characters such as an older mentor figure among the dancers, and a romantic subplot involving club bouncer, protector, and dancer. Very religious parents who disapprove of a daughter's profession, and an overarching storyline of the owner and the performers banding together to save the club from closure. Petitioner asserts that these and other similarities exceed mere tropes. Petitioner asserts that these and other similarities exceed mere coincidence or generic concepts, especially given the uncommon overlap of an inheritance storyline and an LBGT owner protagonist in a cabaret setting. She maintains that P-Valley appropriated the unique combination and arrangement of these elements, making Soul Kittens Cabaret an original protected work. Petitioner alleges that P-Valley unlawfully copied protectable expression from her Soul Kittens Cabaret, which works in a way that goes beyond generic tropes, accounting to appropriating her creative expression. So I know that sounded like a lot. Generic tropes, again, goes back to the common stuff. Like, oh, it's about a club. Oh, they're dancers. Oh, there's liquor. Oh, there's alcohol. Oh, there's a new girl. Oh, there's a love interest. Those are considered generic tropes. But the concept and story of a LGBTQIA community member who inherited a club from a loved one, who is in a down low relationship with someone, who discovers that a homophobic antagonist wants to come in and manipulate everyone in the club so that they could take it over for a casino development, makes it an original protected work. So it is the story beginning, middle, and end, and all of those substantial similarities that make it protected, okay? So then we get into the procedural history of the case. So in your writ, you have to kind of, because again, judges are not sitting up watching YouTube videos of me rant and tell what's going on. So I have to break this story down in a way so that they understand it from legal terms. Because of course, everybody, anybody could be emotional and say, they stole something from me, but you have to show where you have done the due diligence and followed the judicial procedures, right? So this is the procedural history of the case. Many of you know, but here you can find it all in one place. How about that? So on January 12, 2022, petitioner, through counsel at the time, I'm unrepresented right now at the Supreme Court, but I had counsel for almost 5 years. On January 12, 2022, petitioner, through counsel at the time, filed a copyright infringement action against respondent. The suit was initially filed in the Northern District of Georgia. Still, it was later transferred to the Central District of California for the convenience of the parties and witnesses, as P-Valley and respondents had strong connections to California. Upon transfer, respondents were ordered by the district court to file a motion for summary judgment seeking dismissal of the copyright claims on the merits. Okay, so they were ordered by the judge in Los Angeles as soon as it landed there, without any discovery, without any depositions, without me having an opportunity to plead my case. The judge ordered the defendants to file a motion for summary judgment to dismiss my case. My lawyers had never heard of it. I asked a few other lawyer friends that I had spoken to, had they ever heard of it? They did not. So I don't know what was going on there. I just know that the judge was like, get it out of here at that point. The district court decision: in the Central District of California, respondents moved for the summary judgment, arguing that P-Valley was not substantially similar to SKC as a matter of law. Remember, I told you guys that as a matter of law was going to be coming up periodically. It was not substantially similar as a matter of law, which is why it's so important for these laws to be considered seriously. Respondents also moved to strike the expert report and declaration submitted by petitioner's expert, Mr. Robert Aff, which compared the two works. The district judge, Honorable Stephen V. Wilson, held a hearing on September 18th of 2023 concerning the expert evidence and other pre-trial issues. After that hearing, he granted the respondents motion to exclude the petitioner's expert report and declaration. The court determined that the expert's analysis did not materially aid the court beyond the comparisons petitioner herself made, characterizing the report as merely reiterating generic similarities between the works. With the expert evidence excluded, the court evaluated substantial similarity on summary judgment. So basically, the judge looked at my expert report. This is the federal judge in Los Angeles. Judge Wilson said there's nothing to see here. This expert report doesn't really show us anything other than what the plaintiff presented. So December 7th, 2023, the district court issued an order granting summary judgment in favor of the respondents and dismissing petitioner's copyright infringement claim. So he ruled in favor of Stars and Lionsgate throughout my expert's report, and he had a detailed memorandum, and they applied the Ninth Circuit's two-part test for substantial similarity, extrinsic test, an objective comparison of specific expressive elements and filtering out unprotectable content. And in the intrinsic test, a subjective comparison of the work's overall concept and feel. The court concluded that after filtering out elements it deemed unprotectable, such as generic ideas, stories set in a strip club environment, stock characters, and commonplace scenarios, the remaining similarities between SKC and P-Valley were insufficient for any reasonable jury to find substantial similarity in protected expression. The court's order noted numerous differences between the works. For instance, the club owner in SKC, Tata, is a gay man motivated by preserving his deceased lover's legacy, whereas in P-Valley, the owner, Uncle Clifford, is a non-binary person facing financial struggles, preserving his grandmother's legacy. The district court also pointed out that specific plot devices in P-Valley, such as a looming casino development and political corruption, either didn't appear in SKC or they were only mentioned a few times and were superficially similar to the petitioner's story elements. In sum, the district court judge held that the petitioner failed the extrinsic test because the overlap between the works related primarily to scenes of frere, which are elements that flow naturally from a setting or genre, and other unprotectable ideas, and thus no triable issue existed on substantial similarity. Given that conclusion, the court did not conduct an intrinsic test analysis for the jury, which entered judgment for the respondent. So the intrinsic test is whether or not a common, regular everyday person would look at it and see similarities, just because there weren't enough, in the judge's opinion, for that to happen. I'm almost at the end of this, you guys. So the Ninth Circuit appeal, the petitioner timely appealed to the U.S. Court of Appeals for the Ninth Circuit. On appeal, the petitioner argued that the district court abused its discretion in excluding the expert's report of Mr. Aft, who is the name of my expert, which the petitioner viewed as crucial evidence explaining the similarities between the works, and that the court erred in granting summary judgment because substantial similarities should have been a question for the jury, or at least because the court misapplied the legal standard by filtering out too much and overlooking the pattern, similarities, and sequence and arrangement of events between SKC and P-Valley. The petitioner emphasized that the expert's analysis of the 57 specific comparisons between the works, which taken together demonstrate a unique overlap, not explainable by mere coincidence or tropes. And then there is a video that, I have a link there for the Vimeo video, which you guys can all see if you go to wirfmedia.com. I'll include a link in the description where you can actually see the side-by-side comparisons of it. Okay, the Ninth Circuit panel, Judge Susan Graber, Sanchez, and Holly A. Thomas unanimously affirmed the district court in unpublished memorandum opinion issued on December 16th. A recording of that is available on their YouTube channel. I think I shared a link for that as well. The Ninth Circuit first addressed excluding petitioner's expert evidence in its memorandum deposition. The panel held that the district court did not abuse its discretion in striking Mr. Aft's specialist report and declaration, citing that the Ninth Circuit precedent, right? So this is what's been established 9 times out of 10 by wealthy defendants who have beat underfunded plaintiffs. These are the precedents that are established when you have the money to just be in an endless court battle. The panel held that the district court did not abuse its discretion by striking Mr. Aft's specialist report and declaration. Citing Ninth Circuit precedent, the panel noted that a trial judge's evidentiary rulings are afforded a high degree of deference. The panel agreed that the petitioner's expert restated the same list of alleged similarities that petitioner had already identified, excluding many similarities that were at a high level of generality or involved unprotectable elements. The Ninth Circuit cited Rice versus Fox Broadcasting for the proposition of expert testimony highlighting generic similarities and expressive content that does not alter the analysis. The panel further commented that even if they were to consider the expert's report in full, it would not change the outcome of substantial similarity determination under the law. Determining the merits of the substantial similarity, the Ninth Circuit reviewed the summary judgment. The panel reiterated that the governing standard to prove copyright infringement, a plaintiff must show ownership of a valid copyright and access by the defendant's to the work, and substantial similarity between the defendant's work and protected expression of the plaintiff's work. For the similarity prong in literary and dramatic works, the Ninth Circuit employs an extrinsic and intrinsic test. Still, only the extrinsic test is important for summary judgment purposes. The panel proceeded to filter out unprotectable elements of SKC, such as generic ideas, stock themes, scenes of frere that naturally flow from the premise of performers in cabaret club. After the filtering, the panel compared the remaining elements of Soul Kittens Cabaret and P-Valley. The Ninth Circuit agreed with the district court that copyright does not protect many purported similarities. For example, the story of a club, performers in a nightclub or strip club is a basic premise and not protectable. Agreed. Common character types such as ingenue newcomer, club owner, rival, villain, financial motives, and settings in a neon-lit club with a stage were considered standard fare for this genre. The panel observed, as the district court did, substantial dissimilarities in the specific expression of characters and plot. SKC's owner Tata faces a homophobic antagonist aiming to take over his cabaret club by exploiting moral clauses and commandments, whereas P-Valley's Uncle Clifford faces a very different homophobic antagonist, a local politician whose motivations in profit and power, with the threat coming in the form of a foreclosure and casino development deals. The Ninth Circuit noted some similarities petitioner asserted were either mischaracterizations or drawn from elements outside of the core works. For instance, the comparisons that cited materials left with Lionsgate are themes not directly presented in copyright scripts themselves. In the end, the panel concluded that whatever random similarities could be found scattered throughout the works, they were not enough, quoting Litchfield and Spielberg. They warned courts that they must be particularly cautious about inferring copying from random similarities. The panel also addressed petitioner's argument regarding the combination of elements. It acknowledged Metcalf-Botchko allowing a unique selection and arrangement of otherwise common elements to be protectable. However, the panel held that petitioner had not demonstrated the striking similarity sequence and arrangement in Metcalf. It found the order and structure of events in P-Valley and SKC were not closely aligned in a protectable way, aside from broad, abstract parallels. Accordingly, on December 16, 2024, the Ninth Circuit affirmed the grant of summary judgment to respondents, and petitioner's request for rehearing and rehearing in bank, which is with the whole court, was subsequently denied on January 22, 2025. Having exhausted her appeals in the lower courts, petitioner Nicci Gilbert Daniels now respectfully petitions this court for review of writ of certiorari. I'm going to get into the next page, but I wanted to say this real quick. So as you'll notice, at the Supreme Court level, at the appeals court level and the federal court level, both referenced previous cases, right? So it almost feels like making judgments and rulings in other cases fit into my case was the idea here, because Rice versus Fox Broadcasting, where expert testimony was used in a case, I believe it was a case about magicians, right? Expert testimony was thrown out, and it completely paralyzed the plaintiff. When they mentioned the Metcalf-Botchko series, they talk about selection and arrangement, which is another prong that was created from a high, well-funded corporation in a copyright case against a probably underfunded plaintiff. I'm not saying every plaintiff was underfunded, but the likelihood of most plaintiffs having billions of dollars to fight a billion-dollar corporation is very slim to null. So the point is just these cases that they're comparing it to. Metcalf. What Metcalf basically says is, even if you have a bunch of things that are considered unprotectable, even if you got the restaurant and the LGBTQ and the casino and the whatever, if they are in the same sequence, meaning new girl arrives with a red vintage suitcase, LGBTQIA owner is in an undown-low relationship he inherited from the mom or from a relative, a homophobic antagonist comes in to try to take the club, old boyfriend from the past comes back and hems everybody up. In the end, the new girl nobody likes saves the club. That is the same sequence and arrangement. In SKC and P-Valley, it's almost identical. Now, when they start talking about dissimilarities, basically, one of the appeals court judges said, well, when I look at Soul Kittens Cabaret, it's light and it's brightly lit and it's well lit and you can see everything. But then I look at P-Valley, it's dark and there are themes of drugs and there are themes of crime. And it's so a judge, and no disrespect to any of the judges, but a judge wouldn't understand that when you adapt something from a stage play, when things are playing out on a stage, they have to be well lit. They have to be bright. The audience has to be able to see it. And how much darker in theme do you get than character in Soul Kittens being a product of the R word? There was definitely rugs. There was definitely prostitution. There was definitely crime, and even GUNs, pops. On a stage play in Soul Kittens Cabaret, which is part of the reason I adapted it to a dramatic television series. And then when they start saying that I'm mentioning elements that are not a part of my story or copyrighted materials, that is not true, because copyright law says the minute that you put pen to pad and write something down, it is protected by copyright. This pilot episode that I left with Lionsgate and Stars was in fact copyrighted with the Writers Guild. It wasn't a federal copyright, which is the reason why I could not, well, the federal courts did not give it the weight that it should have, and said I was just randomly picking stuff. No, I wasn't randomly creating things. This was in written materials that was left with the CEO. But because of all of these rules that have been able to be established by large corporations that just decide they want something and they just, how do you fight that? How do you level the playing field if these rules and laws have been established by wealthy defendants that have prevailed against underfunded plaintiffs? How does the playing field become level if you're holding it up against impossible odds? But let me continue. So this is where it gets a little juicy. And what's interesting is my writ is actually, I'm not going to go through all 111 pages, but for those of you who know me in Brownstone, 111 is a really meaningful number. I had no idea it was going to be 111 pages until it came back from, the person who formatted the pages for me. And that is Maxie's birthday. So I know it has her blessing all over it, by the way, just a little tidbit. But these are the reasons for granting the writ of certiorari, or the reason that it should be granted. This is super important. All the other stuff was just me telling them what had happened was, basically. So the petition for writ of certiorari should be granted for 3 independent reasons. First, the lower court's exclusion of the petitioner's expert evidence presents an essential question about the role of expert testimony in copyright cases. It implicates fundamental fairness in the adjudication of complex creative works. Second, the Ninth Circuit's decision to deepen uncertainty and potential conflict among the circuits regarding the standard for substantial similarity, mainly how combinations of unprotectable elements are treated at summary judgment, warranting this court's guidance. Third, the issues raised are broad significance to authors and entertainment industry. And this case is an excellent vehicle for clarifying the extent of copyright protection for creatives, expression in stories, and proper procedures to ensure fair evaluation of infringement claims. The exclusion of the petitioner's expert report presents a serious issue of due process and fairness. The exclusion of petitioner's expert report, affirmed by the Ninth Circuit, raises a serious due process concern and undermines the proper role of expert analysis in copyright litigation. Expert testimony is often critical in helping juries evaluate nuanced similarities between complex works, especially in cases involving detailed artistic comparisons. By striking the expert analysis, the court below denied petitioner a fair opportunity to present her case and improperly assume that the jury's fact-finding role, as Judge Paez cautioned in Hanagami, summary judgment is not the appropriate stage to resolve questions of creativity and originality. And, as Judge Kozinski noted, in determining whether a defendant appropriated protectable elements protectable expression and a function reserved for a jury, this case often offers a significant opportunity for the court to clarify the standards governing expert admissibility, protectable expression, and judicial expression in copyright cases. I don't know why my fonts are acting crazy, but anyway, expert analysis is often vital in substantial similarity determinations. Under Federal Rule of Evidence 702, expert testimony is admissible when it helps a trier of fact understand the evidence or determine a fact in an issue of principle. This is especially critical in copyright cases involving complex literary or cinematic works. The Ninth Circuit has consistently recognized in cases like Swersey versus Carey, Zindel versus Fox Searchlight, that expert analysis is not only admissible, but often essential in applying the extrinsic test for substantial similarity, particularly to filter out unpredictable elements and focus on original expression. Petitioner's expert, Robert Aft, evaluated 57 specific plot, character, structure, and theme parallels between Soul Kittens Cabaret and P-Valley comparisons that would be difficult for a lay observer to identify or assess without expert guidance. By striking the testimony, the lower courts not only departed from Rule 702 and binding Ninth Circuit precedent, but also deprived petitioner of the necessary interpretive framework to present her case and respond to any defense expert, leaving the fact finder to evaluate technical, creative elements without the benefit of expert context. The exclusion of petitioner's expert was an abuse of discretion under the circumstances. While trial courts have discretion in evidentiary rulings, the discretion is not boundless. Significantly, when its exercise may encroach on a litigant's ability to substantiate her claims. Here, the district court struck the expert's report on the view that it was merely restated similarities the petitioner alleged, but petitioner respectfully submits that this reasoning conflates the report's content with its purpose. Mr. Aft did far more than list similarities. It provided context, explaining why those similarities were not trivial or random, and it addressed the critical question of whether the shared elements were protectable expressions or unprotectable ideas. For instance, the expert opined on the sequence of character introductions and the plot twists in SKC and P-Valley. They follow an almost parallel structure, e.g., the newcomer's arrival, the inherited backstory, the looming external casino threat, the climactic resolution involving the club's fate. These insights directly counter the defense contention that any overlap was due to only generic tropes. By striking the expert report, the court prevented this explanation from being a part of the record. Notably, there was no claim that Mr. Aft was unqualified or that his methodology was unsound. The exclusion was not based on Dubert or similar reliability challenge. It was excluded essentially for perceived redundancy or irrelevance. This is precisely where petitioner believes the court abused its discretion. Given that substantial similarity in this case involved dozens of comparisons, an expert synthesis could help demonstrate the cumulative effect of those similarities. Dismissing the expert's contribution as having the same generic, dismissing the expert's contribution as having the same generic similarities, petitioner alleged ignores that an expert might lend credibility and clarity to those allegations. If an expert independently finds some overlap, the corroboration should bolster, not weaken the case for similarity, especially if the expert can tie those overlaps to protectable elements. The decision to exclude crucial evidence implicates due process at a fundamental level. The petitioner invested significant resources to obtain expert analysis, now as a pro se litigant, no less indicating how vital she views this evidence. To have it entirely disregarded curtailed her opportunity to make her case. This court should grant certiorari to consider whether the lower courts applied too restrictive a view of expert evidence in copyright cases, potentially conflicting with Rule 702 and with the practices of other circuits. So I'm almost done, you guys. I have about 2 or 3 more pages. Okay, so just bear with your girl. But this is going to be good information, baby. It'll always be here. So if you got to come back, then please do. The decision below illustrates overfiltering and misapplication of the combination doctrine. Even under Ninth Circuit precedent, the panel misapplied the substantial similarity standard by overfiltering and ignoring the protectability of selection and arrangement in these elements, as recognized in Metcalfe-Bacco. There, the court found infringement, not isolated components, but in the shared sequence and relationship to events. An approach petitioner mirrors here. Both SKC and P-Valley feature a young woman with a red suitcase arriving by bus or a gay or non-binary club owner battling a homophobic rival tied to the club's past, a plot to take over the club for a casino, stage performances as character exposition, and a climax centering around saving the club. While each element alone may be generic, their combined appearance in similar narrative order reflects creative authorship. Yet the lower courts dissected those details microscopically, dismissing differences like gay versus non-binary, and failed to consider whether the overall progression would strike the ordinary preserver as substantially similar. Circuits such as the 11th weigh the cumulative impact that allow close calls to reach a jury. This court's review is needed to confirm that originality can lie in the arrangement and common elements as Feist affirmed. The summary judgment is improper when reasonable jurors could differ on whether overall expression has been unlawfully appropriated. All right, so we want to ensure proper balance. I know this seems like a lot, but you all, this is what, so you see what I've been doing, right? Review is also warranted to address a broader procedural concern, the balance between filtering out unprotectable content and preserving genuine issues as a fact for a jury. While an important tool to dispose of meritless claims, summary judgment must be applied carefully in copyright cases. This court has cautioned that judges should not invade the jury's function in determining how an ordinary observer would view two works, notably when the works embody creativity and storytelling that can evoke different impressions. There is a tension between the understandable judicial impulse to weed out claims based on similarities or public domain elements and the right of a plaintiff to have a jury decide whether a defendant took the heart of their work. In the present case, petitioner respectfully maintains that the lower courts went too far regarding filtering and skepticism, effectively resolving factual inferences against her. Granting certiorari would allow this court to examine and set the standard for appropriate summary judgment in close copyright cases. For example, the court could clarify that if a plaintiff presents a substantial collection of similarities, especially in a similar sequence, that courts should be cautious before declaring those similarities non-actionable as a matter of law. This would also align with the notion that at some point, quantity and quality of similarities becomes a factual question, right? This is a question of impression or emphasis, which are what juries are for. The substantial similarity issue here is not a one-off. It's fact-bound dispute. It implicates a recurring question in copyright litigation and the protection afforded by copyright, and because this case offers an ideal vehicle to address broader concerns. Okay, I am literally down to the last 2 pages. I promise you. Where was I at? B. I'm sorry. I think I was going on without you guys. Review is warranted to address broader issue of filtering out. Were we there? Oh, concerns. I'm sorry. Both petitioner Soul Kittens Cabaret and respondents P-Valley explore experiences of Black women, LGBTQIA individuals in the context of nightclubs and performance art. These narratives contribute to cultural conversations that have unique creative elements. Petitioner is a relatively small independent artist known for her work in R&B group Brownstone under the name Nicci Gilbert, who poured her life and experience and creativity into SKC. P-Valley is a big budget television series backed by at least $100 million investment from a major entertainment company. The case thus highlights the classic dynamic, an individual creator versus a powerful industry player. The legal standards and copyright laws mustn't be stacked so high against the individual that potentially meritorious claims are dismissed without a full airing. If indeed P-Valley appropriated core expressive elements from plaintiff's work without credit or compensation, failing to address the harm could discourage authors from sharing their works or scripts out of fear that large studios can take the essence of their creations with impunity. On the other hand, if P-Valley was independently created or only drew on truly generic concepts that can be vindicated through proper fact-finding, the concerns here is that the current doctrine, as applied, might allow clever copying of unprotected ideas, but produce a similar aggregate creation. By intervening, this court can reinforce that copyright does not protect the original. By intervening, this court can reinforce that copyright does protect the original combination and arrangement of ideas into expression form, thus safeguarding the interest of writers and creators whose works might otherwise serve as uncompensated inspiration for profitable derivatives. This case also touches on the role of diverse stories in entertainment. The petitioner's work and the respondents show both center in communities and perspectives historically underrepresented in mainstream media. Ensuring robust copyright protections encourages authors from all backgrounds to tell their stories, knowing that the law will protect them from misappropriation. The court's guidance can thus have implications for innovation and diversity in creative content. Last 2 pages, y'all, I promise. So this is very important. The need for clarity to avoid inconsistent justice. The fact that petitioner's claim was rejected at summary judgment, while another fact finder might have viewed it differently, and indeed while members of the public have noticed the similarities and debated them, indicates the need for clarity in legal standards. From the public and petitioner's standpoint, the rules for what counts as infringement of a story in a script are somewhat opaque and vary by jurisdiction. They lack clarity, and this can lead to forum shopping and uncertainty. By resolving the questions presented, the court can provide a uniform rule or at least a clear parameters. For example, what threshold of similarity is needed to reach the jury and how courts should treat expert evidence in making a determination. Moreover, the appearance of fairness in the judicial process is at stake. The petitioner proceeds. Okay, let me stop. I'm at the last page. I'm starting to get punch drunk. Moreover, the appearance of fairness in the judicial process is at stake. The petitioner, proceeding pro se after trial, fought hard to bring her case this far. The perception that her evidence was summarily dismissed, thrown out, case decided without a jury, and she is now ordered to pay the respondents a 7-figure, which is grown, settlement that could erode the trust in the system's ability to handle David versus Goliath battles reasonably. The Supreme Court reviews would show that even pro se and independent creators' grievances are heard at the highest level, reinforcing confidence in the rule of law. And this is the vehicle statement, which is basically me saying why my case is a good vehicle for the Supreme Court to use to help improve the laws and protections for creatives. This case is an ideal vehicle for resolving pressing legal questions at the intersection of copyright law, expert testimony, and due process. The Ninth Circuit squarely decided the issue. The record is complete and no procedural barriers exist. The core questions are legal. Whether the lower courts erred in striking expert testimony and granting summary judgment in a complex infringement case where substantial similarity turned on the selection and arrangement of elements. The decision below deepens a growing circuit split and risks sidelining juries in close, fact-intensive cases. Without clarification, courts may continue applying inconsistent standards that deny under-resourced creators a fair opportunity to be heard. Granting certiorari will restore balance, affirm the jury's constitutional role, and ensure copyright law protects original expression without punishing creative overlap. For the foregoing reasons, petitioner Dr. Nicci Gilbert Daniels respectfully prays that this petition for writ of certiorari is granted. So, guys, that is it. Well, that is not it. There are actually several other pages because the court wants to see the Ninth Circuit's judgment and orders, and Judge Stephen Wilson, he had maybe a 45-page order in summary judgment explaining why. And then I was also able to, let me show you guys this. So one of the other things that they requested from your girl, hold on, find it. Where is it? Hold on, guys. I'm going to find this. I thought I pulled it out. I'm sure I pulled it out. So one of the other things that they asked me for was, why am I not finding it now? The devil is a liar. Oh, I'm going to find her. Hold on. So this kind of actually worked in my favor. Okay, I can't find it right now, you guys. I'm trying to essay. Okay, supplemental appendix. Here it is. So the fact that the court asked me for this, which this is a supplemental appendix. It's probably going to show the wrong way. Oh yeah, it's showing the wrong way. So this is basically the side. You guys can see it. This is basically the side-by-side comparison. I will make that available. I don't want to. I have to flip it around. But this is, hold on. See if I can do it real quick. Yeah, it's not doing the whole thing. Never mind. That is what some people have called a boon or a plus for my case. The fact that the court saw enough to ask to see the side-by-side color comparisons, which was a separate booklet that I presented. And I know that sounded, this whole thing, it's an hour and 15 minutes of me reading this petition, but I felt like it was important because there are people who are curious, and I know a lot of people don't want to go through and read, these filings and stuff, unless it's Diddy or Tyler Perry or somebody like that. People don't really read it. So I took it upon myself to read it, and I hope you guys learn something from it. I'm not going to the Supreme Court for myself, because the Supreme Court is not where you go and pursue something that is about self. It has to be something that is going to make life easier for other people. It has to be something that either goes against precedent. And I feel like I have proven that I at least deserve the opportunity for them to have me come into the court and present all of my facts and my evidence once and for all. And the bottom line is, I want to read this because this is a statement that, I'm going to wait. Actually, I'll wait. You guys have been with me long enough. But I do have a statement that I might read tonight on Nights with Nicci. So I am going to do a live. I wanted to do this earlier and share this with you guys. But what I'm fighting for is so much greater than myself. And it's important for our community to understand how big this decision will be for creatives. We are people who make a living, many of us, in the creative space, whether it is business ownership, whether it is performing on something. Black people have excelled in entertainment, and entertainment is worth, Goldman Sachs just talked about live entertainment being $70 billion or something in the coming years. The Katori was given $100 million per the CEO of Starz to produce this show. So the value that we bring in the long run, and how that contributes to the economy, and how that continues to the generational wealth and wellness of the people who distribute it and the people who own it, it's a crime. It is a crime that underfunded plaintiffs are bullied out of those IPs that generate billions of dollars. And all we are asking is for a fair, amicable, reasonable piece of the things that we create. And I pray to God that the United States Supreme Court sees the value in allowing my case to be heard. If the only reason they allow me to go forward is for it to be a deterrent, once and for all, for billion-dollar companies to think that they can just come in and take what they want without being held accountable. If that is the only reason, give me the chance to be heard so that it will deter the next person, for fear that they may end up in the Supreme Court hearing explaining themselves. I'm doing this by myself. My sister died of brain cancer March 23rd of this year. I made her the promise I would not quit. And that is the only reason I'm here. And, well, that in fighting for the underdogs. So thank you guys for listening. I won't be long-winded, just long-winded. I thank you guys. I appreciate y'all for taking the time out to listen. And I hope it made sense. And I hope that those of you who wondered why are clear now, more clear now. Okay. So September 29th, Dr. Nicci Gilbert Daniels versus Lionsgate, which is the parent company of Stars that produces P-Valley, will be heard by 9 justices in the United States Supreme Court. And you just heard me share what I presented to them that they're going to discuss. And if you missed this or you would rather read it yourself, it is available on the Supreme Court website right now as a public document. So go and check it out. All right. I love you guys. I appreciate y'all. And I'll see y'all tonight about 10:30 because we got a lot of catching up to do on just the hot topics of it all. But thank you for riding with me. Again, visit wirfmedia.com where you can see the side-by-side comparisons in video form and anything else. All right. Love and appreciate y'all. Have a great, great week. Peace.